Tēnā koutou katoa. Good evening, everyone, and welcome to this public lecture. My name is Alberto Costi. I'm one of the lecturers here at the Law School. It is my great pleasure this evening, on behalf of the New Zealand Centre of International Economic Law and the International Law Association New Zealand branch, to welcome tonight's speaker. Professor Gabrielle Marceau is a senior counselor in the Legal Affairs Divisions of the WTO Secretariat. Her main function is to advise panelists in WTO disputes, the Director General's Office, the Secretariat, and the WTO members on WTO-related matters. She has a vast experience, over 20 years, at the WTO. She began when the WTO was still the GATT, the GATT Secretary in 1994, and she, for 5 years, from September 2005 to January 2010, she was a member of the cabinet of the WTO Director General Pascal Lamy. Before joining the WTO, she worked in private practice in the province of Quebec in Canada, mainly in sectors of labor law and insurance law. Professor Marceau is also associate professor at the University of Geneva at the law faculty, where she teaches WTO law and WTO dispute settlement. She has taught in multiple institutions, including the World Trade Institute, Université de Paris 1 Panthéon-Sorbonne, Monash Law School, and the Graduate Institute of International Affairs and Development Studies. She's a prolific scholar. She's written numerous books, chapters, essays, articles on WTO law, international economic law, and I think she is about to, with Sir Ken Keith here and Georges Abissab, to have a book coming out soon that they've edited, entitled, very interestingly, Evolutionary Interpretation and International Law. We all look forward to this book coming out soon. She's a former president of the Society of International Economic Law and a member of several working groups of the International Law Association. Professor Marceau holds a PhD from the University of London, an LLM degree from the London School of Economics, and an LLB from the Université de Sherbrooke au Québec. Tonight, she's talking about an incredibly interesting topic, very important subject, the World Trade Organization and climate change. Actions are necessary, but how can we leverage trade in our climate change response? Big question. We're looking forward to listen to you, Professor Marceau, to give us some elements of answer to this. Please join me in welcoming Professor Marceau.
Good evening. Thank you very much, Professor Costi. Thank you to your center. Thank you again to the Government of New Zealand for inviting me here tonight. The topic I suggested, and I'm happy that many people are interested, is, of course, WTO and climate change. And I would like to refute and disagree publicly with the line that WTO rules basically limit or even prohibit governments from taking actions for dealing with climate change. And I will begin and conclude in saying that acting on climate change is the responsibility of states, among other actors, and the WTO cannot be an excuse for not doing enough. Now, the first allegation that is difficult to disagree with, many people would say that increase in trade has increased, of course, some climate change, and they point to maritime transportation, aviation, etc. It's difficult to deny that the increase in trade flow has also increased the problem of climate change. But it's also important to realize that trade can help climate change, including, and I won't go into too many details, but the suggestions that climate-friendly products and services can be tariffed at zero, and if we favored certain products at the detriment of others that are bad for the environment, this would help, and this is entirely possible under the trade rules. As I said, states are sovereign. Why is it that they don't do enough on climate change? And maybe put it differently, why is it that people refer to the WTO? Because the WTO is a trade body, it's not an environmental body. So my plan tonight is to speak briefly, maybe 30 minutes or so, and then leave more time for questions. And I will try not to be too technical, but I think we need to share an understanding of the basic rules of the WTO and why you have these allegations made by some governments or some people. The WTO is a club, as the GATT was, and one of its basic provision is the prohibition against discrimination, like in many clubs. Discrimination in particular based on origin. So a product coming from country A that is like a product coming from country B, that is like the same product in your country, should be taxed the same way, should be regulated the same way. Traditionally, however, the big issue was about this likeness. What do you mean a product that is like a domestic product? Traditionally, and this has changed, and that's one of my purpose tonight, if I take two products, and these were the two glasses, if I take these two products and imagine there's a frontier here, country A and country B. The rule is that if this glass is like this glass and this one is imported into country B, both being members of the WTO, the imported glass cannot be treated less favorably, cannot be taxed more, cannot be regulated disfavorably with respect to the way this domestic glass-like product is treated. Easy. Not so easy, however, if I tell you and ask you, are these two glasses like? Are they the same? Are they similar? What would you answer? Yeah, well, but just the glass. Probably. Now, if I tell you this glass is made by children below 6 unpaid, this is made by a machine, are they like? If this one is made in violation of environmental treaties, Paris Agreement, other agreements, and this is made in respect, are they like? If this is made in violation of the fundamental rights of the ILO, labor conditions, and this is made in respect, are they like? In the GATT days, and to some extent today still, likeness, which is the backbone of the non-discrimination principle, was determined looking at the physical characteristics and consumers' perspective, essentially a market determination. And in most countries, unless there's a labeling requirement, people, consumers, rushing to a shop to buy glasses, not knowing that one is made by children or in violation of the environment, the other one being, will interchange them. And traditionally under the GATT, and this is still true today, the primary determination of likeness is a market determination. And if it's possible that in some markets, consumers would not treat the same products on the basis of the method of production, the general rule was that if they're more or less physically the same, they're the same, therefore you must regulate them the same way. Things have changed, not because the determination of likeness has changed, but because in the WTO, in parallel to the likeness and non-discrimination rules, you have in place for 70 years provisions called exceptions that have become rules. GATT Article 20, which was never used before the WTO, that is part of the WTO, GATT Article 20 lists policies that governments can invoke to justify not respecting the market access rules. A fundamental one is this non-discrimination principle. So Article 20 states very clearly, nothing prevents a government from, and for instance, taking measures necessary for the protection of public morals, taking measures necessary for the protection of health, taking measures relating to the conservation of natural resources. And what has changed fundamentally is the architecture, where the GATT focused essentially only on these market access rules. The new appellate body of the WTO has read the GATT and the WTO in a more global perspective, highlighting a few facts. A fundamental one, which was, in my view, a turning point, is that contrary to the old rules, the WTO has now, as one of its goals, the respect of sustainable development. And on several occasions, when there were disputes, the appellate body has said this reference to sustainable development changes things. It brings a new color, a new texture, a new dimension to old terms, 70-year-old terms. The appellate body talked about the need to interpret these old terms in today's reality. Hence, my first introduction to evolutionary interpretation and this desire to research more about this concept in other systems. And I have to realize, to admit that I realize that it exists. WTO did not invent it at all, but it has had a fundamental impact, in particular for the so-called trade and issue, trade and environment and trade and climate change. That is, all the things that other than trade. And what this new case law has brought, in focusing in particular, but not only, on this reference to sustainable development, is to read the exceptions of the old GATT of Article 20, first in saying that governments and countries, but members of the WTO, have all sorts of obligations other than trade in life. And they may need to give priority to non-trade concerns, which was, in a way, a revolution, although terms were written there for 70 years. So, in some of the cases, including in the very first case, the so-called gasoline case, where Brazil and Venezuela sued the United States, who had a regulation on clean air, invoke the need for clean air and climate change indirectly, but treated or mistreated or disfavored imported gasoline vis-a-vis the way domestic gasoline was treated. In its first cases, the appellate body said it's finished, the time where GATT was read in clinical isolation from the rest of international law. And in the case afterwards, although in that case the US lost, the right of the United States to say, I care about the environment, was recognized as a fundamental right. And this right of governments to give priority to non-trade concern was repeated and repeated in several cases afterwards. The other thing that changed vis-a-vis this set of exceptions, where the appellate body said, these are not exceptions, these are rights, and these should not be interpreted narrowly. There are rights that are equal to the market access right, and it's for each government, and if there's a dispute, each WTO judge, to maintain this balance, to respect the right of governments to give priority to non-trade concern, while at the same time, to the extent possible, respect the rights, for instance, of exporting country. The other step and I'll bring all this back to climate change after, is that traditionally in the GATT, governments could deviate from the non-discrimination rule based on physical aspects in invoking Article 20, which was rarely done, and when done, never accepted. But the theory was that you could invoke Article 20 if there was another treaty confirming that your regulatory distinction was fine. If you want to consider that these two glasses are not the same because of the way they're produced, if there's a treaty that says so, you could, under the GATT, invoke this treaty and then treat them differently. The appellate body has said that because Article 20 lists policies that are as important and often more important than trade, you need not a treaty to support. You can go ahead unilaterally. And it said that the essence of all these policy, health, morality, are often, not necessarily, but policies that are unilaterally driven, at least initially. In addition, a new agreement within the WTO sort of treaty called the Technical Barriers to Trade Agreement, this is an agreement about technical regulation, first said that there's nothing wrong with PPM. What's PPM? It's the term used for process and production method, the way things are made. Under the GATT, the way things are made was not relevant. Remember, this was signed, this treaty, the GATT, after the Second World War, and the idea was to increase trade, to rebuild Europe, etc. And any sort of excuse to treat products differently was considered negative. It was a club, two products are alike, you cannot treat them differently if they are alike. The TBT agreement, 50 years after, recognized that the way things are made can be the basis of a different treatment if the regulatory distinction is based on legitimate objective. This, in a way, was a revolution. What's a legitimate objective? The treaty lists some of them. Environment is one, security, and health. Any legitimate objective can be the basis of treating differently products if this discrimination, if you want, but it's not called discrimination if it's justified. Any regulatory distinctions that is based on legitimate consideration or objective is fine, so long as it's even-handed. In other words, so long as you treat similarly situated countries in a similarly manner. If this is made by children, and this is also made by children but come from another country, or in violation of the environment, both, you as importing country, if you decide that you do not want that, you must treat all products coming from different countries the same way. The club idea of the origin neutral criteria remains. Now, let's bring this to climate change. Environment clearly is protected under sustainable development, one of the goals of the WTO. And for lawyers, you know that provisions of the preamble can be very important in the interpretation of the rules, whether main rules or exceptions. And what has happened is that we haven't had a case on climate change, except on one occasion, which had nothing to do with climate change as such. Brazil decided to ban the importation of recycled tires from the EU, saying, I want my own producers to start recycling tires, because all these second-hand tires everywhere in Brazil, where there's no recycling industry, is bad for health, is bad for the environment. And Brazil banned this, and was challenged by Europe, saying, oh, why do you do this? And Brazil says, I do this because if we run out of recycled tire, the industry will want to please consumers and will start going into recycling. And Europe said, yeah, but there are all sorts of fiscal way and taxes, etc. To do the same thing, you don't need to ban trade. Brazil and the appellate body recognized that Brazil being a developing country, the first best alternative, if you want, may not always be appropriate. And therefore, even if an import restriction is not the only way for stimulating recycling, in the case of that dispute, Brazil being a developing country, the problem being sort of important, this was fine. In that case, however, Brazil lost, but eventually rectified, but it shows the hierarchy of norms. Brazil said, yes, I ban retreated tires from Europe, but not from Paraguay. So people said, why not Paraguay? You tell me it's for health reasons. It's because I have a free trade agreement with Paraguay. So the appellate said, what do you mean a free trade? You tell me it's for health. If it's your priority, it's a non-trade concern, free trade is really secondary. So Brazil was told, yes, you have a right to ban trade of these retreated tire if you want to do it for this policy, but you cannot deviate in your implementation of this policy for consideration that have nothing to do with health. It's a health invocation. So this brings me to the fact that if it's true that climate change, and I think we all agree, is a problem that will only be dealt with full cooperation, multilateralism, and collaboration, this cannot be denied. Dealing with climate change can also be done with second best and even third best actions while waiting for multilateral collaboration. What does it mean? It means that governments can, for instance, put in place climate change regulations, tax that are climate change related. It is, however, true that rules on subsidies that used to include green subsidies, the green subsidy provision lapsed. It was in the WTO, but it was written for a period until 2000 and was to be continued if there was consensus, and developing countries said no. They said green subsidies are something for the rich countries. We don't want them, or not we don't want them, but we don't use them. We don't want them to continue to exist. So I'm not here to say that the WTO rules could not be improved to deal more with climate change, but rather to try to share with you my view, my personal view, that the rules in place leave sufficient policy space for governments to do more about climate change and to do a lot. So taxes, regulations, zero tariff on importation of climate change friendly products are all sorts of possibilities. What the GATT and still the WTO prohibits, and I should be careful in this public lecture, is when governments cheat or lie, or I don't know whether somebody has a better word in English to say things politely. But if I take two examples of real cases, an old one involving Thailand and the United States. In the 80s, this was before the non-smoking policies, Thailand decided to ban cigarettes from the United States. And when it was challenged by the United States, it invoked this old provision. It's a measure necessary for the protection of health. Everybody was quite impressed. The World Health Organization even said, wow, they're ahead of everyone. So there was a dispute at the time under the GATT, and the World Health Organization even comes, which never happened. And then questions start coming out. So Thailand, why do you ban cigarettes from the United States? Because smoking is bad. And I invoke Article 20B. It's a measure for the protection of health of my people. Wonderful. But Thailand, why do you accept cigarettes from Argentina and not from the United States? Of course, they didn't say what I'll say, but they said, you know, the Americans, they're annoying with their cigarettes. There are too many of them. Okay, but what's the link? Maybe the American cigarettes have more nicotine. Well, then why don't you have a regulation that says in this country, we want X level of nicotine? Because what was also said, not at the time of the GATT, but now I'm opening a parenthesis, is that in the WTO, it was said several times that governments have the freedom to set the level of protection at the level they want. Each government can have the protection they want so long as they're coherent. But let's go back to 88. And then Thailand, you ban cigarettes from the US, not from Argentina, but I see that you also have a tax preference for your own domestic producers of cigarettes. So the answer is, Thailand, you cannot do this. You can decide, possibly, to restrict trade for health reasons, but you must be coherent. Another example that is close to you, in another area, but I think it's a good description, is that Australia, a few years ago, 20 years ago, decided to ban fresh salmon from the Atlantic waters, from Canada and the United States, because all fish in the Atlantic North water have a certain disease. It's not a big disease, but it's a transmissible disease from animals to animals, not to human beings. Australia says, I don't want the salmon from Canada and United States because of this disease. So US challenge says there's no risk, there's no disease. Australia explains the risk. The risk is that one day, Mr. Smith, an Australian, will go fishing on the lake, and before going fishing, will stop by the supermarket and buy Canadian or American salmon, make a sandwich, goes fishing, bites the sandwich, a little bit of fresh salmon falls in the water. By chance, there's a salmon, an Australian salmon swimming that hit the bit of salmon in the eye and catch the disease. So the United States says, in polite terms, you're mad. This is not a real risk. You have to be more willing to do new things. Australia says no. And the court, the appellate body, and was supported by the EU, will say governments have the right to set a zero risk. Many people, scientists in particular, thought it was bizarre, zero risk in science. Nonetheless, this was established and repeated several times. But then the case continues. Australia, you seem to import a lot of lobster from the same water with the same disease. And indeed, I understand that Australia produces a lot of things with lobster and other things. So why are you banning salmon with the same disease? The truth is that in Australia, salmon in Tasmania is fighting a bit to survive, so the government probably wanted to help a little bit. So it was not really health. What the WTO conclusion to Australia is you do what you want. You can ban salmon, but then you need to ban lobster if you want to be coherent. And coherent good faith, or vice versa. What is very interesting in that dispute is that many people ask after, but why is it that the United States and Canada sued Australia? It's pretty far to start exporting fresh salmon. And the answer given was, it's a battle of principle. I want the EU and China and all those who could have similar ideas to know that I won't accept that. And after, I'm told, not much fresh salmon goes to Australia, but New Zealand exports salmon to Australia, fresh salmon. So this is just a case, an old case, almost 18 or 20 years, to explain the concern of the WTO, making sure that when governments say, I have a non-trade concern, and that's why I restrict trade, that it is a real non-trade concern. Now, unilateral measures have happened. France has banned salmon from Canada because of the salmon. Brazil, I mentioned, banned retreated tire. There are many examples where these unilateral actions could go ahead, and therefore climate change related actions could also go ahead. And if there were negotiations leading to some standard, one of the new provisions of the WTO that is also very rich and very relevant to climate change, it's a provision of this TBT agreement that says when a government adopts a domestic standard that is complying with an existing international standard negotiated outside the WTO, when a government adopts a domestic standard that is complying with an international standard, the WTO will presume that this domestic standard is WTO consistent, even if it restricts trade. It's a beautiful example of coherence where the WTO basically give the last call to, or not the call, but the determination right to a specialized body, the standardizing body. That is to say, if governments were to adopt climate change standards outside the WTO, if WTO members implement those standards and restrict trade because of doing that, this would be presumed consistent with the WTO. Now, I'm not saying that there are no problems. And in particular with taxes and this PPM problem, because as I mentioned, this basic idea of non-discrimination where these two glasses are to be treated the same way because they more or less look alike and consumers interchange them, this basic rule has not changed. What has changed is, on the contrary, the right of governments to invoke a policy to treat them differently, even if consumers could not see the difference or even be aware of the difference. So governments could put in place climate change tax and say, I'm going to tax this one and this one the same way, or I'm not going to tax them the same way because this one is not climate change friendly. A priori, an exporting country of these that are not climate change friendly could challenge, could say, what do you mean? They look alike. And the importing country could say, they may look alike, but for me, they're not like, and I'm invoking the right to protect my people, health, and environment. Now, what would happen? And this is where problems nonetheless exist. It goes, if there's a dispute in front of a WTO judge, a WTO arbitrator, and for instance, if it's not about glasses, because it's easier maybe to think about steel and some of the products that are not climate change so friendly, if the importing country says, I will impose a tax of X for climate change, and products that come from country where there's not enough action on climate change, I will treat them as not climate change friendly, so they'll be subject to a higher tax. This country, exporting, will say, what do you mean? My steel is like your steel. There's no difference physically. Consumers don't know. The whole debate would take place in the context of those exceptions, and their issues are difficult. What is difficult is to compare actions by governments, actions for dealing with climate change. So I'll give you 3 examples. The importing country, as I said, put a tax, and those domestically who don't do what they're supposed to for climate change are subject to a higher tax, etc. If the exporting country, for example, is Brazil, and Brazil says, I don't do anything on steel, but since you're invoking sustainable development and your right to protect the environment, I also protect the environment. I plant 3 trees every day. And this helps me comply with my obligations under the Paris Agreement. So you, the United States, if your real problem, or you, United States, Canada, whatever, if the problem is climate change, it's a global problem, and I deal with it differently from you. Can an exporting country say that? Or is the importing country entitled to say, I care about climate change, we will start first with steel? We've had disputes where the United States was said that they have the right to protect turtles among the fish. And some academics would say, if a government has the right to protect the environment, it has also the right to decide where it starts and impose it on the others. The counter-argument, the Brazil type, would say, the problem is climate change. How we deal with it is a sovereign issue. Second situation, China would say, oh, I don't deal with steel, but me, on Monday, Wednesday, Friday, I prohibit people with a family name starting from A to M from driving. I reduce CO2 level of X amount. This is very much in conformity with my Paris Agreement commitments. I don't have to deal with the specific sector. Or India saying, I deal with air conditioning. So there's not only the idea of can an importing country force the exporters in a certain area, but there's a very difficult issue of comparing the impact of actions, different type of actions. And this is where the WTO needs, if there were such a dispute, the help of others and experts. Already in the Brazil tire case, which was more about health and environment, and this was not at all argued by the parties, suddenly you have a sentence there of the appellate body saying, recognizing the right and even the obligations of government to deal with health and sort of problems, societal problems of the nature of climate change, the appellate body says these large problems of health, like climate change, may need a lot of time to be appreciated and evaluated, and we should give that time to the countries that take action. A lot of people were surprised. It was not even mentioned. So it was more a direction saying governments need to take action, and some assessment of the impact of those actions may need time. There are other possibilities. The other issues, regional trade agreements are also areas where actions can be taken and where it may be easier because you deal only with one or two states. Of course, regional trade agreements are not perfect. For instance, one area subsidies needs to be handled with care, but in particular, it's very, very difficult for two governments to deal in a bilateral free trade agreement or otherwise with subsidies on climate change. Two governments could say, we will agree on each other using subsidies, but then the outsiders will usually oppose or disagree with these actions. Subsidies, very difficult issue to deal in regional trade agreement. And the same with technical regulations. It's not that it's bad, it's a first step. And you know, my approach is that the WTO allows, of course, for first best action, but second best and third best. Regional trade agreements can include climate change actions, but in certain areas it could be more difficult. There are also trade preferences. A few years ago, Europe and all rich countries in the WTO are allowed to treat better in terms of border tariff importation from developing countries. And they're allowed also to put conditions. And what conditions? This was a bit of an outrage for developing countries because they said, how come it's the donor countries, in that case Europe, who can decide whether or not I will benefit from a reduction of import tariff if I comply with ABC requirements. And in that case, EU lost, but EU won the battle of principle. And the appellate body said that the purpose of trade preferences, the purpose of what is called the enabling clause, which is a decision of the 70s, that allows rich countries to treat better products from developing countries. The purpose of this rule is to help developing countries in their development. So, and because developing countries are in different level of development and different situations, a criteria that is development-based is acceptable so long as, always the same, countries similarly situated vis-à-vis that criteria can be treated similarly. It's after that ruling that the EU put in place what is called the GSP Plus, where they say, for instance, importation of table in Europe will be subject to a 30% tariff. But when it comes from developing country, if they have signed X environmental convention, I'll go down to 25. If they ratify human rights convention, I'll go down to 20. If they ratify labor convention, I'll go down to 15. Of course, a lot of big developing countries were offended, as I mentioned, saying, well, how come they decide what's good for our development? And the answer was, this is a right of developing countries to give tariff preference. We're not obliged. We could stop that. But if the criteria, and I would argue that protection of climate change is certainly for the protection of the planet and the development of our countries, if this is integrated in trade preference, it could help. Of course, this is just for developing country, but it's an example. And finally, the WTO allows, and it's already in place, a subgroup of members to adopt zero tariff amongst them for products that they think are important. And even if it's concluded between a subgroup, it's okay so long as the benefit are given to all. The MFN provision that you must treat all members of the club the same way. Some governments, in the context of IT products, have decided that even if only, I think it's 70 members out of 160, or maybe a bit more now, have signed this agreement, they together represent what is called a critical mass. I think 87% of trade. So they said, let's put tariff at zero on these technical products. Of course, zero for everyone, but we initiate the process. Why not do it again on environmental goods? There is a proposition out there about putting to zero environmental goods. Goods that favor climate change at the detriment of other goods that don't favor climate change. It's difficult at the moment because China said, oh, I'm not sure I'm interested, and then Europe says this and that. So the critical mass for traders affects. But my point is that the legal system, the rules of the WTO, are not at all against a smaller group leading and eventually expanding to include more people. I'd like to conclude in saying, the way I started, in a way, states are sovereign. It's for states to act, not alone, and not only states. It's for individuals, it's for firms, corporate multinationals. But the ultimate responsibility cannot be on the WTO, and it's too easy for governments or others to blame the WTO. There's sufficient policy space and flexibility in the rules, especially the way they were interpreted, allowing governments to take action. And for them to take action, and here I'm talking as a citizen, it's also for us to push on this. More needs to be done on climate change, and the WTO, in my view, can only help in this process. Thank you.